Here.
Commissioner Aon?
Here.
Commissioner Liu?
Here.
Commissioner Ward?
Here.
First item on the agenda is public comment. They're appearing or not appearing on the agenda. They're open to jurisdiction of the Ethics Commission. Before the first speaker begins, I'd like to say that we're going to keep very strict time today on public comment. 3 minutes are going to be given to each speaker. When the buzzer goes off, I'm going to ask you to sit down and you can give consent to the left of the day. Thank you.
Good afternoon. I'm Dr. Maria Rivero. I worked at Liquid Honda for 22 years. Then I became a whistleblower. I was harassed and I was driven out of my job. We reported a potential conflict of interest between the then health director, Dr. Mitchell Katz, and a contractor, Health Management Associates, to the Ethics Commission in September of 2009, almost 2 years ago. In 2005 and 2006, Health Management Associates was awarded a $250,000 contract to assess and work with the health department. Within 2 years, then Health Director Dr. Katz got onto HMA's payroll as a consultant. Starting in 2008, Dr. Katz received over $10,000 a year from Health Management Associates. In 2009, the Health Department paid Health Management Associates $65,000 to provide consulting services, while at the same time, Health Management Associates was paying the then Health Director over $10,000 to do consulting work for them. In 2010, the Health Department extended HMA's contract twice, boosting the money that they made from the city from $65,000 to $103,000. Dr. Katz recommended and signed off on HMA's contract extensions while pocketing another $10,000 plus from HMA that year. All told, HMA was paid $103,000 by the city in the past 3 years, and in the past 3 years, Dr. Katz was paid at least $30,000 by HMA. This is a relatively simple complaint. However, after 22 months of us providing documentation regarding this to the Ethics Commission, it's yet to complete its investigation and make a decision. Meanwhile, Dr. Katz has left town. Why was this complaint buried? Why were we not protected from retaliation? And what happened to our whistleblower complaint that's now 16 months old while we lost our jobs? Thank you very much.
Good afternoon, Commissioners. My name is Patrick Minette-Shaw. I'm a private citizen here on my own time. On June 21st, Heather Knight and Will Kane published an article in the Chronicle about the grand jury's report, San Francisco Ethics Commission, the sleeping watchdog. Knight quoted John St. Croix as saying he was, quote, confused and saddened that they used the approach they did. You'd think there is a chaotic mess and no such thing as truth, end quote. To many observers, the Ethics Commission is a complete mess. And the grand jury's report barely scratched the surface. This commission should order Mr. St. Croix to begin investigations promptly after the 14-day window. This commission should unrelinquish your authority you have handed to St. Croix by requiring him to change your regulations for investigations and enforcement and start scheduling hearings on all referrals to ethics, not just those recommended for dismissal. As commissioners, your duty is to protect San Franciscans, not to protect Mr. St. Croix. Interestingly, today's whistling in the dark grand jury report isn't so kind to the Ethics Commission either. It notes that back in 2003, then as now, your sole job, your sole function is to administer and enforce campaign finance law. In addition, the new report indicates that your sole duty under the whistleblower program is to investigate complaints of retaliation. Why is Mr. St. Croix stalling on responding to an order of determination from the Sunshine Task Force on my two complaints, 113 and 114. He was ordered to turn over some documents. I haven't gotten them yet. I'm going to get them. And this commission needs to rein in Mr. St. Croix that he may not unilaterally disregard an order of determination from the Sunshine Task Force.
Members of the Commission, my name is Ray Hart, Inspector of San Francisco Open Government. The last time I was here was during the special hearing regarding Mr. Shoemaker's exemption, and I said some things that one of the members of the audience afterward says I didn't show enough respect. I was in the military for over a decade. One of the things I learned very quickly is that you respect an officer's uniform, but you don't necessarily respect the officer if that person does not have the capabilities or the attitude or some of the other things that go along with fulfilling the duties of that uniform. David Brooks wrote an article in the New York Times about 6 months ago and called the responsibility deficit. And in that he said, the heart of any moral system is the connection between action and consequences. Today's public anger arises from the belief that this connection has been severed in one realm after another. I have gone to library commission meetings, police commission meetings, 6 or 7 different types of meetings, and in every single one of them I have had instances and seen instances where I either experienced and was told this or saw other members of the public told, you can't talk about that. I'm sorry, this document right here is what we're really talking about. Yes, Sunshine Ordinance may be your purview, but a Sunshine Ordinance violation, it is in many cases a violation of the Brown Act, the California Public Records Act, the California Constitution, and the Constitution of this United States. There isn't one single board member on any single board, including you, that has the right to tell a citizen they cannot talk to you about something they feel you need to hear. That's what the Constitution is about. And it rises to a higher level of protection when we're talking about the fact that you're petitioning for a redress of grievances. I had the president of the police commission tell me, you're not allowed to talk about that. And I said, sir, you're violating my constitutional rights. He says, no, I'm not. I'm just enforcing our rules. And he actually did stop me because I thought to myself, who in God's name does this man think he is that he has the power to supersede the Constitution of the United States? And I had to take him to Sunshine and get a determination where they found him in violation of the Sunshine Ordinance. And I'm actually thinking about filing a complaint with the California Bar because the man's a practicing attorney, a former public prosecutor, and he must have some knowledge of the Constitution of this country. And to tell citizens of the United States, citizens of this city, when they come before a body, you can't talk about that, is just a downright lie. And anybody who doesn't stand up for that is violating their oath of office. You took an oath to support and defend the Constitution of the United States and that of the state of California. And yet, in all the years that the civil grand jury report covered, you didn't do one damn thing.
It's okay.
Totally different topic. My name is Judith Brodesen. I am a citizen of San Francisco. I am here on behalf of my sister, who lives 2 blocks away from me. It is my understanding that the 311 call system can be used anonymously and should be anonymous, and that any complaints that are listed anonymously cannot state who they come from. And this is a complaint because my sister does not, there's construction next to her. She is known to the city to have put in complaints, or rather she tried to file against them getting a variance and against the building commission accepting it. And so she's known to be opposed to this construction. I noticed, and she does track the complaints, however, I noticed that there's a complaint number 201148869. And although you're supposed to, if it's anonymous, not have any indication who, this is what it says in the comments. This is another frivolous complaint, see previous complaint, neighbor at 67 Granada may be complaining as workers say she comes out asking questions and taking pictures. The building is gutted, plumbing work has not begun, abate. Whether or not she did the complaint, I don't know, but actually I know she didn't because she was in Nicaragua taking care of her partner's ill mother. So here we have the 311 call unmasked. Moreover, a month ago, before she left to go to Nicaragua to take care of her mother-in-law, the city building inspectors decided to pursue visible trash can. Now, I do believe that this was also a retaliatory. There's been a number of complaints, I don't know whether or not, and which ones my sister may or may not have done through the 311 call, but my sister and her partner are both city employees and should be covered under whistleblower ordinance. So these are two different violations of whistleblower ordinance. I have sent emails to your commission, and if you need my phone number or how to get a hold of me, they are within those emails, because I don't want to violate any of her or my own past communications, which should be covered under whistleblower. I don't want to discuss this anymore here in public, but would like to, and would like them to be discussed privately. Thank you for your time, and I appreciate you listening.
Good afternoon, Commissioners. I'm Richard Nee, immediate past chair of the Sunshine Ordinance Task Force for record-keeping purposes as KNEE, just like Elbow. Just want to give you a brief update on where we are with the review of the proposed guidelines for the Commission's handling of sunshine complaints. We're almost there. It's been perhaps longer. It's been a lot longer than we would have liked, perhaps longer than you would have liked. We really appreciate your indulgence, your patience on this, but we are, as you are, we're an all-volunteer body, and sometimes we have difficulty maintaining or even mustering a quorum. So we're doing our best anyway. Within the next month or two, we're going to be sending you our comments, and we look forward to discussing them with you.
Good evening, Commissioners. My name is Dr. Derek Kerr. After 20 years at the Luna Honda Hospital, I became a whistleblower, and then I lost my job. In 2009, we reported a potential conflict of interest between a contractor, Davis, Jaw and Associates, and executives at CBHS, Community Behavioral Health Services, a division of the Health Department. CBHS awarded a contract to Davis Jaw based on a proposal that showed a deep, almost an insider's understanding of the issues facing CBHS. Within weeks, the contract payment was doubled, but only half the work was delivered. The study was flawed, but it praised CBHS. We wondered, how did CBHS award this contract to Davis Jaw and Associates? Well, property records showed that the CBHS Director of Research, Evaluation and Quality Management, a Deborah Sherwood, PhD, resided at the same address as Davis Jaw and co-owned the office building of Davis Jaw and Associates. We reported this to you and to the whistleblower program, this undisclosed personal and business relationship, back in September of 2009. Now, 22 months later, your investigation is still ongoing. This matter needs your attention for 3 reasons. Number 1, in 2009, Davis Jaw received another city contract to help CBHS for $1.9 million. The same potential conflicts of interest that existed when this major contract went to Davis Jaw rather than to UCLA, these were the conflicts that we had reported almost 2 years before. And lastly, we were driven out of Laguna Honda within 6 months of filing this complaint. So please, responsiveness to whistleblower complaints. Thank you.
Good evening, Thomas Picarello. A couple of things. First, I see that on agenda item number 3, you have a possible consideration of responding to the grand jury's sleeping watchdog report. I think your agenda is too loaded tonight to seriously address all the issues raised in the grand jury report. So what I would suggest to you is that you have a special meeting just on the grand jury report and their recommendations. And secondly, let me say this. The Sunshine Ordinance Task Force sent you an oral determination May 16th regarding a complaint I have against Ann Cronenberg. A couple days ago, I got a phone call from your staff to begin the investigation. You should not take 8 weeks to begin an investigation on an order of determination. The lawyers on this committee are aware of the legal maxim that justice delayed is justice denied. When you deny someone access to public records or public comment, you're doing a disservice and you're not living up to your responsibilities that you were appointed to do. Thank you.
Hi, Kimo Crossman here. I actually wanted to say, I wasn't going to speak now, but after what Mr. Picarello said, I actually agree with him. The grand jury report is actually, has a lot of detailed feedback, and just to have it as one agenda item of an otherwise busy meeting, I think would not allow for a full and complete discussion. Certainly I have input on a lot of the items, and 3 minutes won't allow for that if you have them all called as one agenda item. So I would recommend having a special meeting as Mr. Picarello recommended as well.
Good afternoon, I'm Sue Coffin. I have an item later on the agenda, but I really did want to say something about the grand jury report. I didn't have a chance to read all of it, but I do think it's enormously important. I'm a member of the Sunshine Task Force, and some of the things that it recommends regarding sunshine is something that strikes a chord with me. So I do hope that you have it at a time when we can all come down and talk and give it the attention that it deserves. Thank you.
Next item on the agenda is consideration of ethics complaint 01-100115.
Good evening, Commissioners. I'm Garrett Chatfield for the public. We've calendared this matter for you to determine the applicability of Section 6734 of the Sunshine Ordinance. I just want to clarify, this is not a probable cause hearing. That would come later, depending on what your decision is tonight. There are 2 issues that are within the memo. Basically, the 6734 can be enforced against the Commission Secretary, Sue Blackman, and whether or not 6734 can be enforced against the Commission President, Joel Gomez. The memo outlines our understanding of how it should be applied, but of course, that's a policy decision for you to make. Before you begin your discussion, I would like to play the video for you just so you understand what conduct occurred, so that you can see for yourself what was outlined in the memorandum. And then after that, I'll happily answer any question you have regarding what staff proposed. just for the members of the public, I put this audio on as loud as I can, but it isn't very loud, so just be aware.
And you see.
Good afternoon, I'm Sue Cawthon. I'm talking about North Beach, but not about design. I just wanted you, I think you all know that I head a coalition of groups who are concerned about the present plan, and I've passed around.
Can you hold that until we get to that item? That's a North
We
Beach
talked to
item.
the city attorney, and
This is a North Beach item. Will you hold it until we get to it,
North
please?
Beach item is
Will you hold it until we get to it, please?
the North Beach item.
You hold it? Are you not listening to me?
The North
Sit
Beach,
down!
the North
Sit
Beach
down.
item is
Sit
about
down.
design.
Please
This
sit
is not
down.
about
Please sit
design.
down. Please sit down. Please sit down. Thank you.
So, just after staff review that, we do feel a violation of Ms. Cawthon's right to public comment occurred. The issue is whether or not 6734 applies to either Joel Gomez or Sue Blackman. The way the text of the law reads, it says complaints involving allegations of willful violations of this ordinance, the Brown Act, or the Public Records Act by elected officials or department heads of the City and County of San Francisco shall be handled by the Ethics Commission. Joel Gomez is an appointed official by the mayor. Sue Blackman is not an elected official or a department head. So the matter is with you to determine how you want to read that section.
Would someone from the task force or Sue Kaufman, do they have any comment on this before we discuss amongst the commissioners and then open it up to public comment?
Hi, Sue Coffin. I just wanted to let you know I fell on Saturday night and banged my face up. But my doctor actually said you should be resting in bed, but I really wanted to come today because I think this is an extremely important issue, not just about the incident that you just witnessed, but the general subject of proper treatment to the public. And one of the reasons I'm a longtime member of the Sunshine Task Force is that I believe passionately in public participation in government. By the same token, I believe that government should treat people with respect, whether they agree with them or not. I'd be happy to answer any questions.
Ms. Coffin, perhaps we can hear from Ms. Gomez.
Microphone, please.
Perhaps we can, if we have further questions, maybe we can recall you if that's okay with you.
Okay, will I have an opportunity to make public comment?
Yes.
Okay, thanks.
Good afternoon again. I am still Richard Neal, and I chaired the hearing of the task force at which the order of determination, that resulted in the order of determination that has come before you and is the subject of the hearing that you are about to embark on. Let me just point something out to you, and I want to take issue with something in Mr. St. Croix's and Mr. Moe's and Mr. Chatfield's analysis, in which it is said that there is no named respondent in that complaint. And that technically might be true. However, in the order of determination that the task force issued, the revised version of August 13, 2009, in the section titled Findings of Fact and Conclusions of Law, first sentence, based on a DVD recording of the meeting, a transcript of the meeting and testimony presented by Sue Coffin, as well as several members of the public, task force finds that Joel Gomez willfully violated the ordinance. So even though technically there might have been no respondent named in the complaint, the task force did find that Joel Gomez violated the ordinance. And I hope that you will use that as guidance going forward. Any questions?
Thank you, Mr. Chief. Is Ms. Gomez here?
Gomez, President of the Library Commission. Shall I just make a statement?
Right, if you have anything to say, I'm giving you an opportunity to do so.
Okay, thank you. I feel compelled to add some context to your deliberations and to add that the video that you see is not the entire video. What you miss at the beginning is me asking the previous speaker to also sit down and wait for the agenda item. Because unlike this commission, our commission asks people to speak in general comment only on items that are not on the agenda. As a novelist and playwright, words are my stock and trade, so use of the word willful in the complaint disposition is my primary concern. It implies incorrectly a deliberate attempt on my part to violate the Brown Act. My intent on curtailing Ms. Coffin's testimony was the same as when I curtailed the speaker who preceded her, who then politely took her seat and returned when the item came up and spoke on North Beach. I was upholding the policy followed in all previous Library Commission meetings. All elements of a particular topic have traditionally been confined to that agenda item, whether it explicitly said all elements or not. We had traditionally never covered an item in both public comment and again in the specific agenda item. My raising my voice was indecorous. It was a result of Ms. Coffin's refusal to stop speaking when I asked her more than once to reserve her comments for the appropriate agenda item. I was then assured by the city attorney, the deputy city attorney, at the meeting that I was correct in asking Ms. Coffin to wait for her agenda item to speak on North Beach. Since I have no idea ahead of time what Ms. Coffin is going to say, there would be no reason for me to stop her speaking because, as she implies, I disagree with her. But she chose at that particular time to reinterpret our traditional practice and refuse my request for her to wait her turn. In doing so, I felt she showed great disrespect for the commission and its process. I felt it was my responsibility to uphold the protocol and not allow a new precedent to be set, which might have some audience members speaking twice on a single item. What was willful, however, I feel, was the task force deliberate scheduling of their meetings when they had been informed that unfortunately neither I nor the commission secretary would be available. And being informed quite ahead of time that the particular day they chose for a meeting was also the day that my board of directors meets, and I have a difficult time not attending that meeting, and still they continue to schedule. Or the commission secretary indicating she had a planned vacation scheduled, so could not come to the upcoming meeting, could it be delayed. But they decided it should be scheduled at any rate. I did attend the meeting. I testified. I acknowledged that the wording of the introduction to public comment might be misleading. I had the wording changed so there would be no further misinterpretation. This rewording was immediately approved by the deputy city attorney. Further action seemed unnecessary since the original dispute about the appropriate time for general public comment versus comment on an agenda item seemed to have been clarified with the new language. Despite this tangle of disagreements evidenced by this complaint and the calculated and repeated provocation by some members of the public, it is my honor to serve the people of the city of San Francisco and the San Francisco Public Library. Thank you.
My name is Zach Stewart,
Sorry,
and
sir.
I'd like to...
Excuse me, sir. We're going to have public comment about the matter after the commission. We're going to have public comment about this matter after the commission deliberates on it. We wanted to hear from those who were directly involved.
I didn't, okay.
Thank you. Commissioners, any comments?
Well, I think I do. I mean, I think I saw something different on the video than what Ms. Gomez stated. I saw Ms. Coffin trying to explain what she was hoping to say, and frankly, Ms. Gomez losing. I mean, I don't know whether Ms. Coffin would have retreated and taken her seat after she said her piece about what she was trying to say, but it wasn't a very civil exchange from the chair, and it's hard for me to understand how someone sitting in the chair would treat a member of the public in that way. I mean, I've been on this commission for now 6 years, and I've never once seen anyone in either of these chairs treat a member of the public in that way. On the other hand, I've taken a lot of abuse from the podium, yet I've never seen anyone react on this side in that way, and I think it's unconscionable that someone who's an appointed official or an elected official in the city would respond to a citizen in that manner.
Other comments from the commissioners?
I have a question. Ultimately, did Ms. Coffin have a chance to express her views under the future agenda item, or not? Were you finally able to state what you wanted to state at that particular meeting?
No, it never was. But as the gentleman said, the problem was that Ms. Gomez did not let me tell her what I wanted to say. She just assumed that it was something connected to the agenda item 2, which it was not. So therefore, I was unable to speak generally in public comment about an issue involving citywide libraries. And as I say, Ms. Gomez for some reason assumed that I was going to talk about item 2, which was peer review of the design of the North Beach Library. And that was not my intention at all, but as I said before, she simply wouldn't let me tell her that.
And did you have comments about the North Beach Library during that library agenda item, though?
You mean the second agenda?
Yes,
Oh, yeah, sure.
So you did speak
I spoke about
on that topic?
Yeah, but I didn't get to speak about my issue regarding preservation of citywide libraries. That was what I wanted to talk about in general public comment.
Thank you.
While we have Ms. Coffin up here, do any of the other speakers have questions for her?
Has Ms. Gomez ever apologized to you for the tone of her response?
No, I was really blown away because I was the founder and chair of the Board of Supervisors Library Advisory Committee. I've been coming to library commissions since 1988. I chaired a library support group called the Council of Neighborhood Libraries. I know, as a member of the Sunshine Task Force and a citizen advocate, I know the rules for public comment. I know the rules for general public comment. And I was really overwhelmed when she kind of lost control and just screamed at me. And it had a chilling effect on some of the folks who came down with me because they wanted to talk about item number 2, North Beach. But they also had general public comment remarks they wanted to make, but they were afraid to speak. No, neither Ms. Gomez nor the commission has ever even mentioned this subject.
Thank you very much. Ms. Gomez, it looked like you had a response to Commissioner Haon's question.
Ms. Coffin indicated she was going to speak about North Beach. That was what she started saying. I said, please wait till the North Beach item. She did get up and speak, and she did speak about North Beach. Whether she spoke about what she had originally talked about, I don't recall because I did not see the full tape. But for her to say she did not speak, had no opportunities to speak was incorrect. And I agree with you. I said it was totally indecorous. I felt very assaulted by her. Because when I'm sitting in this position and you ask someone to sit down, as you've done today, they sat down. There was no question, there was no rebuttal. They sat down. And I felt that was very disrespectful to the commission to keep talking when I say, please hold that until the North Beach item. So, yes, it was inappropriate behavior. I should not have snapped at her, but I thought she was very disrespectful to the commission. If she would like a public apology, I would certainly say, I apologize for that behavior, which my great-grandmother would not have approved. But the point was still on target, as far as I'm concerned.
Ms. Gomez, do any members of the commission have any questions for her while we have her up here? Thank you. Any further comments from the commissioners on this matter?
I mean, I agree with Commissioner Ward 100%. What we saw in the video, I didn't see any assault or disrespect from Ms. Coffin or Ms. Gomez. I don't understand why it would have elicited that reaction, but even regardless of whether someone, a member of the public, is even borderline disrespectful, that was completely unacceptable for someone in Ms. Gomez's position as chair of the commission to behave in the way that she did. And I think that is a willful violation. I know we still have yet to talk about the interpretation of the statute on its application to individuals, but I think there was a violation of the Sunshine in the sense that it was unacceptable behavior.
Commissioner Studley?
I'll just add briefly that I agree with both commissioners on that point completely. There is a special responsibility that we hold to be sure that we understand what a speaker wants to do. We now have Ms. Coffin's word for what she intended to say, and that it was never possible to get that during the hearing. I have no problem with Ms. Gomez wanting to treat each speaker in a similar way, but without giving her an opportunity to explain the point of her comment at that moment, she could never get that. But I am very troubled by the jurisdictional issue, and it would be very frustrated, but I don't see a way around coming to the conclusion that an unacceptable thing happened, but that we may not have the tools to address it given the statute. So I'm happy to talk about that whenever you want, Mr. Chair, but it feels like a very tight situation with a problem where we are not the ones who have the solution available to us.
I concur with that. I too am troubled that we don't, because, like all of you have said, this appears to be a willful violation. Especially having seen the video, the notion that the chair felt disrespected given the response, I think is not credible. Are there any further comments with respect to
there must be something that we can do, even if it's not within the ordinance. She was appointed by someone. Maybe there's a letter that we can write to that person expressing our feeling about what happened and requesting that whoever the appointing authority is reconsider her service on the commission. And perhaps it doesn't hold any authority, but we can at least do that.
I agree with Mr. Ward, and I think one thing we may do is, as the staff suggested, with a slight modification, refer the matter to the mayor with a statement that Ms. Gomez's conduct willfully violated public testimony requirements of Sunshine Ordinance Section 67.15.
I would support that. I think the staff recommendation makes sense, and I would support your addition to that we make it a very strong, a letter in which we are very clear about what we have found. But I was just not heading there because we hadn't talked about whether we in fact agreed or saw some other way that we could assert jurisdiction. But I don't hear any analysis that would get us to that. It's, I think after we determine how we want to handle that recommendation and if there is support for a letter, whether to think about in the appropriate process, whether we should have, whether there's something flawed about our jurisdiction, whether this is a hole that we want to fill, but obviously we can't do that under our rules tonight. We're limited to thinking about how to bring this to the attention of the appointing authority, and I would support your recommendation.
It's just that because of the way the drafting of the ordinance is, it appears there might have been an intent for this enforcement power to exist, but whatever drafting error didn't occur to it. But if you could determine that your jurisdiction was supposed to be there, if you're comfortable with that, but because it's not specifically stated, staff couldn't take that across the finish line. It's a policy decision that you may wish to.
Is that something that we could address tonight, or was it not noticed? And
we can't change the policy tonight, but you can determine that that's what you think should happen, and we would have to do more work on it.
I'm sorry, I don't quite follow what you're saying, right? So are you saying that you believe there may be an argument that the policy rationale would provide a different meaning? Okay.
As everyone's noted, the ordinance itself leaves a lot of blanks about the Ethics Commission's jurisdiction, and the staff's memo, I think it's the same. The proposed regulations regarding enforcement of the Sunshine Ordinance, which the Commission considered in May of last year, and which Mr. Nee referenced earlier, address some of those issues and get into specifics about how you can enforce the ordinance, what penalties might apply, what the procedures would be, and against whom you can enforce. It's been our recommendation that because of the ambiguities and in the ordinance itself, that the Commission not impose any specific penalties that aren't explicitly set out in the ordinance until those regulations have been adopted, because the Charter grants you the authority to interpret the ordinance by regulation, which is promulgated in this certain process under the Charter. Is that?
So you're saying when we come back to looking at the regulation, this may be, we may sufficiently have addressed it some time ago, or have an opportunity then to make sure if we'd have the tools we wanted in this situation.
Exactly. I think you at least started to address it in those regs, and I think maybe even fully addressed the concerns that you're raising today.
So staff presented to you what we think are your alternatives under the current regs.
Right, okay. Thank you.
Thank you.
I understand. At this time, I'd like to open the matter up to public comment.
Good afternoon again, Commissioners. Patrick and Shaw. I would like to just sway you from the mistaken assumption 67.34 applies only to elected oaths or officials and department heads. The sentence clearly says that it applies as well to, quote, or other managerial employees. You don't have to quibble about the jurisdiction of this. Sunshine Task Force ruled that if there was a violation of 67.34, your job isn't to discuss jurisdiction. Your job is to discuss enforcement. You don't get to decide whether it applies to other managerial employees or not. The Sunshine Ordinance is quite clear on that sentence, although I would admit that 67.34 does have a little bit of ambiguity in it that needs to be resolved when the Sunshine Task Force moves forward revisions to the Sunshine Ordinance. As it is, you don't have a jurisdictional issue that you can drive a BART train through here. You just have to rule that 67.34 was violated. That's all you have to do.
Good afternoon. My name is Peter Warfield. I'm Executive Director of Library Users Association. I've been attending Library Commission meetings pretty much without fail for more than a decade and certainly attended this one. First of all, I want to say that it's unfortunate that you were only shown the very short section without the context that has been referred to by the President of the Library Commission with respect to the prior speaker, and nobody has said anything about the speaker who followed. So I have a tape recording of the meeting. I get all of the recordings of the meetings, and I can play you, if you like, or somebody else could, a 3-minute segment that includes the prior speaker, Ms. Cawthon, and the following speaker, who was myself. Let me say that in the first place, the prior speaker was treated very gently and very politely and spoke quite a bit longer than Ms. Cawthon, by my timing 24 or 25 seconds to Ms. Cawthon's 15. She was then very politely asked by the President if she would mind, or words to that effect, holding her comment until the North Beach item was taken up. And she agreed, adding another 5 seconds. But I just want to say, and you can hear it on the tape, and she goes on, and is allowed to go on, for a full 5 seconds saying, I really support the North Beach Branch Library tear down and so on and so forth, and what the Library Commission is doing and so on, what the library is doing. So she was permitted to speak much longer than Ms. Cawthon. She was allowed to continue after being asked to sit down without interruption. Ms. Cawthon, by contrast, was treated quite differently. She was interrupted much faster, with considerable vehemence, as you saw, and was not allowed to say anything at all once the interruption from the President began, and essentially was shouted down and forced to sit down. If you look at the piece you did see, you could see something that I don't recall ever seeing before, and that is that the Deputy City Attorney present at the meeting got up and circled around toward the President while this scene with Ms. Cawthon was occurring. She stopped when Ms. Cawthon sat down and before reaching the President. So I don't know where the President gets to say the City Attorney assured her she was correct. I certainly would encourage you to ask her when was that said, because the City Attorney never physically got to her. I've been to plenty of Library Commission meetings over the decade and more, and the City Attorney speaks into the microphone in normal circumstances. The following speaker was myself, and because of the tension that had arisen, I spoke very gently and very carefully. But I informed them that what had happened was a violation of the law. Thank you.
Good afternoon, Commissioners. Speaking as an anonymous citizen, of course, stop the hate, the corporate rape of the public library, don't give money to the Friends of the Foundation, don't accept money from the Friends of the Foundation. The first thing you need to understand is that this is not an anomaly. This is one step in a long process to provide open government and public participation at Library Commission meetings. The library is presently required to provide agendas, to allow public comment, to make copies available of documents that are under discussion. This is the result of the efforts of many people over many years. They hate it. You have no idea how they hate it. They hate democracy, reason, decency, and everything connected to it. The predecessor of Miss Gomez was Miss Coffin, was Mr. Coulter. And Mr. Coulter used to use what we now call le mot Coulter all the time. Since you have to have this explained to you, le mot Coulter is bullshit. That may sound a little funny, but when's the last time somebody chairing a public meeting referred to you as bullshit? This is not in order to enforce class barriers. In fact, the Library Commission has been referred to been indicted by grand jury reports, controller audits, post-occupancy evaluations. They received strongly worded letters from the district attorney's office, and they were even sued once by the California Attorney General based on a complaint from me. They don't want the accountability in the future that's been visited upon them in the past. Of course they don't like accountability. Criminals are not supposed to like accountability. There has been solid academic work done which shows that belittling people categorically in this way is a mechanism by which people with moneyed interests are promoted at the expense of people who don't have those moneyed interests and who are being disenfranchised. This is a mechanism that is part of their long history of policy of suppressing the truth and suppressing open discussion because of their private interests. They have not made any contention that they are honest or responsible in any way. What does the Library Commission claim? That they drive crazy people even crazier as part of some sport? Yeah, that's some defense. We should close by honoring Sue Coffin. It takes a lot to stand up to these powerful, ruthless crooks with resources of that level, and as far as I'm concerned, Sue Coffin is a hero. Thank you very much.
Commissioners, Ray Hart, Director of San Francisco Open Government, and I'm confused in the staff report why Ms. Blackman is even in there. Ms. Blackman is an employee of the Library Commission and works at the direction of Ms. Gomez and the Library Commission. Why she is there trying to defend someone else's behavior and actions is a mystery to me. I think it is, number one, cowardly to send someone else to defend me in front of the City Commission for my actions. And I assume that Ms. Gomez did that because she knew she had no leg to stand on and didn't want to be publicly embarrassed in front of the task force. Making up all these specious remarks about, oh, we couldn't make this meeting and they couldn't make that meeting. Their considerations are the only ones there. I showed up for a meeting on a Library Commission complaint 3 separate occasions, and it was discontinued. It was continued for one reason or another, and I came back. That's what the obligation of a complainant is. I think the same obligation applies to the respondent. In fact, the Sunshine Ordinance says they have a duty to respond. But why Ms. Blackman should be charged? She is either told to go or told not to go. She is told what to say or what not to say, and it is all from Ms. Gomez. Now, going back to some questions that you've already asked, I think where this is willful is the fact that this happened in 2009. It has been more than 2 years, and at any point in time, Ms. Gomez could have picked up the phone, talked to Ms. Coffin, and said, you know, I was probably wrong, I'm sorry, and if you'd like, I'll admit it. But she didn't do that. She didn't even bother to participate, and that's what is really willful. When someone takes you to a task force like this, the Sunshine Task Force, or a committee like this body, and you show so much disrespect for the rule of law that you won't even bother to show up or send a representative, I think that just shows a total disregard for the rights of the citizens of this city. And to drag this out for 2 damn years, when at any point in time she could have picked up that phone and made an apology. And I know Ms. Coffin, had she done so, I think Ms. Coffin would have been very generous and said, as long as you acknowledge that it was a mistake, enough said. And that's what somebody has to do, and why I mentioned the David Brooks article. If you're going to sit in one of those seats, you have to accept the responsibility for your own actions. And if you're not willing to do that, you don't deserve the seat, because you're not willing to live up to your oath, and you are not willing to serve the needs of the citizens of this city. And you might as well just admit it and step down and let somebody sit in that seat that will do it.
Good afternoon, Commissioners. It has indeed been 2 years. I had to refresh my memory by the letter that I wrote. I think my letter to the mayor probably started this. I came late that day to the commission hearing, and I was walking down the aisle, and this little small figure was in front of the microphone, and she got out 2 words, and Ms. Gomez started yelling at her. Well, she didn't yell the first time. I thought it was something like 20 times, and her voice got louder and louder. She was completely, totally out of control. It was a lot more than indecorous. I guess she thought a while before deciding to bring that word to you as a way of apologizing. It was a woman that was out of control. I've been to a few meetings in my time, and frequently members of the public get out of control. And you in authority kind of get used to that, but the last thing we expect is for somebody in a position of authority, for that to happen to them. It really was, it sent a chill down my spine. I'm not the only person to whom that happened. Another person that I saw this morning in a meeting, he had another meeting now, he said the same thing. It just chilled us, scared us, chilled us. She was completely out of control. It's a lot more than indecorous. And you probably have seen my letter. I assume that you get packets of some sort or another. Anyway, I wrote on the 14th of June after finding out, I wasn't even clear what Ms. Gomez's name was, and I needed to find out who appointed her and like that. So I called somebody who knew more than I did. I think it was either the first or second time I've ever been to a library commission meeting, and I learned that the mayor had appointed her, so I wrote to Gavin Newsom about it and said that he should give some mind to rethinking that particular appointment. She was completely out of control, and it was frightening. Thank you.
Hi, Commissioners. Kim Crossman. First of all, I want to emphasize what someone else said earlier. Today, your duty is to enforce. The Sunshine Task Force is given the power to adjudicate these matters. They have found a willful violation, and they referred it to you for enforcement. So while I found it interesting to see the video and have basically input from Ms. Coffin and Ms. Gomez, the reality is that's already happened, and I think you're going down a slippery slope if you're going to re-adjudicate everything that comes to you from Sunshine. Your duty is to enforce the matters, and as they're referred to by the body, the Sunshine Ordinance Task Force, which is given the power to adjudicate these matters. Since they found that a willful violation occurred, even when Ms. Gomez was unable to attend a few of the meetings before, she was unable to accommodate her schedule to come to them, but eventually they adjudicated against her. So I would recommend that you take strong action against this person. Well, I think we heard a partial apology tonight, but the word that after Ms. Gomez said she realized her language was indecorous, and then she used the word but, and then described why she thought the member of the public was not respecting the commission. Well, the reality is, as soon as you say "but" in an apology, it means you're really, you're not really apologizing. The "but" counts as what was said before that. And the other thing too was when Ms. Gomez said that the city attorney said what she had done was appropriate. Well, the city attorney is just, that's just their opinion on some matter. Probably wasn't in writing for one, and for two, we all know that you guys make the policy decisions. You don't always accept the advice from the city attorney as well. You make your own decisions too. And ultimately, task force made the ruling. They're the body that's empowered to make those rulings, and it's your responsibility to enforce them. Thank you.
Commissioners, Thomas Picarello again. Well, you're at least being consistent. So this is number 19 order of determination that you have denied coming from the Sunshine Ordinance Task Force. The reason that Ms. Gomez can display the demeanor that you saw on the monitor tonight is because you have no accountability in the system. The Ethics Commission is to be there to have accountability. Clearly, there was a serious and willful violation by Ms. Gomez. You talked generically about not having the tools. It would be more interesting to hear the specifics as to why you feel you have not the tools to uphold the order of determination by the Sunshine Ordinance Task Force. So I urge you to reconsider your motion and uphold the Sunshine Ordinance Task Force and find a serious violation by Ms. Gomez, and also refer her to the mayor's office who appointed her to her position. Thank you.
My name is Zach Stewart. I've been testifying off and on in front of commissions for 50 years. And I am absolutely sure that all of our commissions are the lifeblood of the city. A friend of mine who is a retired controller of the city and county of San Francisco said, when I said I'm going down to testify at the library commission, don't bother. He said I went down there when I was controller to point out that the record showed that they completely remodeled their library that hadn't even been started. They paid no attention to me. You won't get very far if you go before the library commission. My one experience of going before the library commission was anybody that agrees with them, and anybody that doesn't agree with them is like, ugh. I felt like a dog, and I decided I didn't need to waste my time with that commission anymore. It's a very arrogant organization, loaded with money, set-asides, and all sorts of money, a big PR operation, and they crush anybody that has any information that isn't something they agree with. You just saw an example of how that works. Believe me, speak out. The Ethics Commission has a role here.
Good evening, Commissioners. My name is Luis Herrera. I'm the City Librarian for the San Francisco Public Library. And I just simply want to offer a few comments on behalf of President Gomez. She was appointed to the Library Commission in February of 2005, was reappointed last year by Mayor Newsom for a 4-year term. She was elected president in February 2008 and re-elected again in 2009, 2010, and 2011. She has earned the respect of her commissioners, staff, and is a leader not only in the LGBT community, but the community at large. And I've been the city librarian during her entire tenure, and I can say that during the entire term of office, she has been fair and professional. She allows all voices to be heard, and she also does it in a respectful and dignified manner. What you saw here was not the Jewel Gomez that has given many, many years of service to our community, and any action simply will diminish her contributions to the city and county of San Francisco. Thank you.
go on.
Sue Coffin again. I'm really disappointed in what the city librarian said. I mean, it seems like he doesn't care either that I was treated so badly. You know, I kind of agree with what Mr. Hart said, that, you know, if she hadn't screamed and shouted at me, I might have just let it go. But when she kind of lost control and just refused to stop screaming at me at high decibels, I thought, this behavior cannot go unremarked. It is not right for a public body to treat a citizen in that fashion. So I certainly hope, you know, while we at the Sunshine Task Force are working on 67.34 to make it more, to clean, brighten up some of the gray areas and make it a little easier for you to refer things on the basis of it. I was around when the ordinance was being drafted, and our intent definitely in 67.34 was to give the Ethics Commission the authority to enforce violations of the ordinance. So I really do hope that you will go ahead with your plan to send a letter to the mayor, because I really think, you know, I'm not out to get Ms. Gomez, far from it. But I really do think that there should be some attention paid to the way she treated me. Thank you.
Enforce 6734.
Good evening, Commissioners. I just want to put in the reality back into this. You did see, I think, the videotape. You are aware of what happened. People do make mistakes. We all make mistakes. It has been 2 years before this got to this point. This conversation that took place 2 years ago, and it's taken all this time to come before this body. Anyone hesitate about punishment? You want to listen to this librarian about this woman and her role as whatever she is? I was a rather strong advocate of the library back when the name was formed, and was back when Mr. Coulter was. If I had known this body existed, and that you were charged with bringing these people to some kind of heel, back then, you would have been very sick of me, because I've been here at least every week. Mr. Coulter created this nightmare that the current librarian has dipped into in this particular episode. That, I might remind you again, is 2 years old without action yet. We really need this. If this city is serious about being city, this is just one conversation between a city librarian and a member of a person who wanted to speak. And it's taken us 2 years to get to this point to resolve anything. I don't know which world you live in, but in my world, if you devote that kind of time to something this small and still do not act, you really shouldn't need to be here. Thank you very much.
Commissioners, any further deliberations?
I guess I just need a clarification. So in the staff memo, it says Ms. Gomez is not a managerial city employee, correct? And so she is not a managerial city employee. So the issue isn't really whether the code, whether we can enforce against a managerial city employee or a department head or just department heads and elected officials. It's just that she doesn't fall under any of the three categories in 6734. I guess that's a question for staff. Is that correct?
That's correct. Neither Sue Blackman, who was the named person in the referral, who's the commission secretary, she could be a managerial city employee, but then let me get the text of the code, because the two sentences, one includes it and then one specifically omits it. So the first sentence, the willful failure of an elected official, department head, or managerial city employee to discharge any duties imposed by Sunshine Ordinance shall be official misconduct. But then, for us to do anything, it seems that the only people we can enforce anything against is the elected official and the department head. So it actually takes managerial city employee out of it. And Ms. Gomez is none of that. She's an appointed official. She's not a city employee.
Right, so the ambiguity in the code has nothing to do, I mean, just Ms. Gomez doesn't fall under any of the three categories in 6734. So, I mean, I think I would support the letter, the idea of the strongly worded letter to the mayor.
I feel the same way. It's as though, I mean, I understand that to some members of the public, this may well sound like lawyers and commissioners arguing over a technicality. And I am very sorry that it so happens that one of the first chances that we have to address an issue referred to us by the task force is one that has this kind of complexity, because I think it obscures the fact that we take this very seriously. This is akin, in my mind, to the situation we would have if a member of the audience at this or any other commission that had to follow these rules had stopped another member of the audience from speaking. It would be unfortunate, it would be a willful and inappropriate act, but if it didn't fall within the powers that we have, then we wouldn't be able to address it using these enforcement tools. What we're trying to do is use the only tool that we have, that was our reference to tools, by bringing this to the attention of the mayor who made the appointment with as serious and expression of concern as we can, and at the same time address the resolution of the ambiguity to the extent it exists, and to think about this and situations that might, I hope there won't be others like this, but should a situation arise, whether our rules would allow us to do it. But right now, it doesn't. She is not in a category that we are allowed to handle in this way, and it points up perhaps a shortcoming of the rules, but I see us proposing to do, if we have a majority for it, to do something that would be our best expression of respect for the rules and concern about this action.
Is there a motion?
I move that we send a letter to the mayor, if that's who the appointed authority is, expressing the views that have been expressed here with regard to the conduct of the chair of the library committee. Attach a copy of the tape with it, and recommend that the mayor consider removing this person as his appointee to the library commission.
Can I suggest that part of your proposal is that staff draft this letter, but that the chair be empowered to have final approval?
Sure, as long as it contains the things that I've just said.
I was just going to second the motion. Yes.
All in favor?
Aye.
All opposed? Next item on the agenda is consideration of possible response to the 2010-2011 Civil Grand Jury Report. Mr. St. Croix,
So, with part of the process when the civil grand jury issues a report, is that there is a response required, and the Ethics Commission is required to respond to all 7 findings. So I drafted a response for your consideration. At this point, if you wanted to have any discussion, ask me any questions, make suggestions, so that the language is representative of the viewpoint of the commissioners, and not just the executive.
What Ms. Gomez just did, she flipped her jacket.
Commissioners, any questions for Mr. St. Croix with respect to the draft response to the grand jury's report?
Yeah, I got a bigger lawyer than she's got.
I wonder if there's anyone who feels, as I do, with regard to the request of several members of the public, that this matter be put over for a special meeting to,
Thank you.
so that there's more time to discuss and have the public weigh in on our response.
I understand that we have a deadline that we
August 15th.
are supposed to respond.
And what happens if we miss the deadline?
We've got no response. We've got no response. Their report stands unrebutted.
Commissioners, the one back
I agree with the notion, to the extent that at least part of it is that there are issues of policy that we may want to address related to some of these matters. But I have a couple of maybe practical thoughts. One is, it may be possible to bring them forward on a regular agenda with respect to those items, because we could say to the grand jury that we are considering a particular one, or this is where it stands right now, but the commission will be going through them systematically, either along with related issues or in the order that we think they warrant in terms of priority. So I guess this suggests I'd rather respond to them to the extent we can. Some of the answers were, it's the will of the voters. Some others are, this is what we're doing now, but we could look at it. Rather than step away from it completely and delay a response. There are some I would very much like to talk to, and I would defer to the chair's decision, you know the rest of the agenda better, whether you would want to have any conversation tonight about this, either both to identify our comfort level with the draft and whether there are issues that we want to return to later. But I fear that it might be difficult to have a special meeting with a good attendance by commissioners in the window between now and August 15th. It's a long enough window, but it's one that has a lot of potential vacation or travel. I just wonder whether we would be missing the opportunity that we have if we didn't discuss it at all.
I totally agree, and I do think that it's with Commissioner Ward. I think that one concern that I have, or an interest that I have, is that I think that the Ethics Commission has an opportunity to be educated, to provide educational opportunities, if you will, for the public in San Francisco. And I think that a special meeting about the grand jury report could be one of those opportunities to discuss what the report has said and to hear from the public, you know, one way or another. I don't think that that precludes our beginning a discussion on how we should respond or could respond to the grand jury, but I would like to see some kind of public hearing where we can hear from the public and further discuss you know, what is involved in the report at length.
I'm going to make a presumption that if the commission doesn't finish its work on this by August 15th, a preliminary response would satisfy the requirements under the law, with the understanding that work is ongoing and that a document will be forthcoming that would further respond to the report.
I actually don't know the answer to that. I think it's the penal code that requires a response in 60 days. I just don't know exactly what the grand jury's response would be if we give it preliminary.
The purpose of putting this on the agenda today was because of the deadline. I am somewhat concerned that setting a special meeting may actually not lead to as much attendance as we have today. It was a very well-attended meeting, and so I am concerned about that. Putting it on the agenda for next month would be cutting it pretty close, because our meeting is scheduled for
August 8th.
So therein lies the problem. Perhaps we could spend some time deliberating on the issue today, provide some guidance to staff, and then continue the matter at the next regularly noticed hearing on August 8th, thereby giving the staff more of an opportunity to come up with a more finished product, perhaps, and then hearing from the commissioners and the public at that time.
I would certainly agree with that.
Is that acceptable to the rest of the commissioners?
Yeah, it's fine.
Okay. Then substantive comments from the commissioners with respect to the draft response. You know, let's do it finding by finding. If that's acceptable to the rest of you. So the first finding with respect to the fixed request that there be a fixed fine structure.
Wait a minute, will you take public comment, finding by finding? Through the chair?
I think we will not take public comment.
Well, that's not quite fair to the public.
Well, like I said, we'll have another opportunity to address the issue at the August meeting. So
we'll have public comment.
Yes, we'll have public comment. It won't be finding by finding today. To the extent there's additional public comment, then the public will have an opportunity on it.
That's why you should schedule a longer hearing.
With respect to the first finding, comments from the commissioners?
I would just mention on this one that I didn't have edits to the issue. It is a subject that has been of interest to us, and the question of consistency, as those who've been attending the meeting over time, is one that we share with the grand jury. That the question of how fines are determined and just as it is for judges, is a very complicated one, and it's one that we've been concerned about. So I think it might be worth saying in the response, simply indicating that it is an area that we agree is important, and we have discussed and expect to return to, because it is something that we watch. We don't have all that many matters that come before us, and they come before us on very, very different violations, factual circumstances, funds involved, and it's an area that's been a challenge to get a handle on. But I think we could reflect a little bit more than this answer does, the degree to which we agree that it's important. I also do not find the specific always apply the maximum allowable fine. We've had some situations in which that would have seemed to be very inappropriate, and I think we were thoughtful in not doing so. But I think we could reflect a little bit more continuing attention to this that would be both true to our history and would, for me, properly reflect the seriousness with which we take this item.
I would concur with that, and I do think that there has to be a balance with respect to this issue, and I agree that a zero tolerance or a fixed fine in all cases is not really in the interest of the public. It's not in the interest of those that are regulating in this respect. I was wondering whether the staff could consider, whether it was practical to consider guidelines for fines.
I was actually going to ask that, whether there were guidelines that are being used or that are used, or whether there's a scale or range that's used in determining fines.
mean, we try to look at similarities between prior cases to give us some basis for these when there's nothing comparable. The process is a balancing test between the level of public harm and you know, the prior history of the actors involved and so on.
Any other comments on first finding? Comments on the second finding and the response there too. I would propose that the sentence following the italicized task force be omitted. I think this is also an area that, I think with all of these, I agree with Commissioner Studley that we should have a caveat that we are working through these issues, and this is this is certainly the response that we, a response to the report and one that we believe in, but that these are continuing issues, all of them, of concern to us and things that we would like to address, because we always, of course, want to improve. Any other comments with respect to finding two? Any comments with respect to finding three? I agree with the draft on this. I mean, I don't know that it's practical to require immediate response on the close of the 14-day window. But I think we should look into whether we can do that and should respond as quickly as practical following the close of that window. Any further comments on finding three? Finding four? Any comments from the commissioners?
I think number 4 is well said. This was the determination of the voters that this was a degree of separation of functions and independence that was that seemed at the outset to be workable, and it's up to the voters to make a judgment about whether they want a different methodology.
Any other comments with respect to finding number 4? I agree with Commissioner Sutton. Finding number 5. Any comments with respect to this? Commissioner Sutton?
I discussed this issue with the grand jury when I met with them, and I was left thinking that they had raised some interesting points, and I would be interested on this one to return to the matter of how we handle these. Not because I think we are doing what they think we're doing, but simply because, because there are appearance issues about whether a negative option is just too easy a bar. I read every single one I get. I read it in time to convey my view. And I have sometimes, but I will say rarely, asked for something to be calendared because I have found that the staff understands the standards, that these are items that seem to be appropriate for the treatment that is being recommended, but I feel no hesitation in saying that it should be calendared if I have either a specific issue with the recommendation or believe it fits into a larger pattern that we ought to discuss and shouldn't just leave to be handled that way. So this one, for me, rather than stand up for the current process, seems to be one where we might do well to just think about what the best way is to carry out our action, carry out our responsibility to make that determination, but also not to feel that simply because of the mechanics of doing it that we are lying down and letting somebody tell us what to do, because I don't believe that is what's happening, but the way that we do it might create the wrong impression. So I think this is one where I would at least like to suggest that we look at that process and whether it's a tweak or a more substantial, think about how we might do that.
Any further comments from the commissioners?
And let me just add, and I appreciate getting the well-substantiated, clear recommendations, and it's partly the homework that makes it possible for me to be able to say, there's a reason I want to discuss that one and believe it should be discussed in the commission, or I can follow the logic, the law, application of the law to the facts, and I'm comfortable with that recommendation.
So, I think Mr. St. Croix, that if you and the staff could go back and look at possible alternative mechanisms for dealing with the complaints, we'd appreciate that. Finding number 6. Are there any comments from the commissioners? Oh, I'm sorry. With respect to finding number 5, I had a suggestion, and I understand the language may change here, but in the second to last sentence, I would remove the portion following decisions, so part, and not relying on work and potential political meetings of their colleagues to inform their decisions. I would strike that. I'm sorry, comments on finding number 6. I found that I thought the response there was good. With respect to finding number 7, are there comments from the commissioners?
I would like to know historically the reasons for why these commission meetings are not televised. I think it would be probably a good idea if we can get the funding. I think it's an important enough issue for public perception reasons and other reasons to see if we can televise commission hearings, but I would like to hear about why historically the reasons for not televising hearings.
It's primarily budgetary. We put in a budget request every year. For the past several years, we've been ordered to submit budget reductions. So the idea that we would put in a request for the cost of televising is just not practical. We've never been fully staffed. We made some progress on that, and that's been rolled back and so on. So when I make a budget recommendation, it's always entirely staff-driven.
Any further comments with respect to finding number 7? In that case, I'd like to open it up for public comment.
Hi, Kimo Crossman. Actually, I'd like to address number 7 first. Lots of departments and other commissions do not pay anything to SFGTV to have their meetings video streamed on, so I'm surprised to see that it's a budgeting issue. The Board of Supervisors can pay SFGTV for any of its long meetings and committee meetings. I'm actually not aware that Mr. St. Croix has even gotten an estimate for what SFGTV might like to charge. But again, many departments and commissions don't pay anything to have their meetings streamed. Some reimburse for the closed captioning, some do not. There's no requirement. The last time I researched it, which is about 2 years ago, there's no requirement for departments to pay their interdepartmental costs to have meetings covered by CCTV. You're not paying for your license.